Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests.
Good morning, everyone, and welcome. I'm Jody. I'm the defenceress, and I have officially started to really dislike Sarah Boone. Yes, that's where I was at, peoples. I sat down about an hour ago just to check Twitter, make sure that everything was still kosher, and I was reading a post up there, and then I had the feed for the trial right next to it on the screen, and I literally watched it change before my eyes. So, yes, it has been postponed until tomorrow. This time tomorrow, apparently. So there is another motions hearing that is about to start now because they've filed more motions. There's more motions in this trial than a gastro ward. And they still need to finalise jury selection, apparently. So that's where we're at, people. We will do the best we can with what we've got. But yes, not a fan. Not a fan. Yes, the trial has been postponed again. About an hour prior to it starting, they changed it. They just changed the time and date, basically. Bless them. Bless them. So, nothing like being given loads of notice. But when I was on Twitter, I found Joel Waldman. He's the I think he's the owner of Surviving the Survivor podcast, and he does a little bit of an update on what's happened so far with the motions hearings, and I think he's been in court and with the jury selection. So I thought, I'm actually watching the feed for the motions hearing, and whilst it is live, they're not doing anything yet. So I thought perhaps we would just watch this, see what he's got to say. Because luckily, I did check Twitter, because what really, really gets my goat is the fact that I stream from Melbourne. So I am 14 hours ahead of Eastern Standard Time. So 9 a.m. Eastern Standard Time, when courts normally start, is 11 p.m. for me. So it is now 10 to midnight, and I have good morning, sweetness. I've spent the entire day prepping to spend the entire night streaming. So I am jacked up, full of Mountain Dew, full of caffeinated products. Luckily for me, I didn't start my energy drink yet. And then they do this. So, yeah. Good morning, sweetheart. So, change of plan. They delayed it again at the last minute. We're going to do the motions hearing. And just, it is what it is. It'll be what it'll be. Simple as that. If I'd have had more notice, we could have done something. Yeah, I know, they're absolute fuckers. That's all I can say. I've just pledged officially that I have taken a real disliking to this lady, woman, thing, person, whatever. And stick your motions in your pie hole. So, all right, let's have a look at what this. I've not watched his podcast before, but I think no. There might be the very slightest chance if they can get through. I think there's 2 motions they have to go through this morning, and they still haven't finalise the jury. So if they get that done this morning, there's a chance that they'll start openings this afternoon. But the feed for the trial, the formal feed for the trial, has changed the date until this time tomorrow. So I'm officially saying that they're not expecting to. They're not expecting for it to start at any time today. I can't offer memberships just yet, sweetheart, because I need 78, I think, 78 more subscribers before I can monetize, and then I can offer memberships. But thank you, that is lovely. I'm so close. It is like a poof, 15th, down to double digits now. Yeah. So, but rest assured, yes. Rest assured, the second that I do cross the line, you will know it. All right. Let's have a look and see what this guy has to say. Now, there's my preset. There we go. Now, as I said, this is the guy who runs the podcast, Surviving the Survivor, who is in court today. I will just boost him because I had to scramble and try and reset and create another full stream. All right. Hopefully you can hear him.
Lunch Live
Whoa.
episode of Sarah Boone, Day 3 here. Hope you all are ready for me because I'm ready for you. Shout out to Anina, come to us from Switzerland. I know you guys were all watching the motions hearing, which ended a short time ago.
About the one
This
we did
is the Lunch Live. Welcome to Surviving the Survivor, the podcast that promises to bring you the very best guests in all of true crime. And that, of course, is the courthouse, the Orange County Courthouse behind me. So please, if you have any questions for me during this Lunch Live, I can't operate the way I do at home. I'm just keeping an eye on the chat, and I'm looking down at some notes as well. So I'll be multitasking here.
So this gentleman has been at the Orange County Court for the last 3 days. So he's just doing a lunchtime update to let us know what's happening up to date, basically. So I've not watched him before, so I apologise if he's crap.
And listen, I don't want to complain because I know some people are watching in Alaska and some people are watching in Norway. Some people are watching in Switzerland.
But come on. Just get on with it. Okay.
The 7 p.m. wrap-up show on the Menendez case. We're not doing Sarah Boone tonight, but the Menendez case. And we've got an amazing panel. We've got Dr. Ann Burgess.
I want Sarah, not Menendez.
Of course, the living legend.
Come on. Come on. No spinning wheel. Oh, come on.
COE, I don't even know if you're behind the scenes here or space. If you want to bring in some comments, that would help me a lot because I just can't click on them the way I'm set up here. But obviously, the real main issue in the motions hearing today was about this battered spouse defense. And basically, the state, what they're saying is it can't come in because there's no evidence that this happened. That there's no overt act. That is the legal term, that there is no overt act. So the state is asking that the defense was asking that the defense not be able to use this battered spouse defense in opening statements. That's how it began, or even later in trial, unless some new evidence would come in. The state just kept pounding this home. There is no overt act, nothing to say that Sarah Boone's life was in any imminent danger. In fact, the exact opposite, that her boyfriend was now zipped into a suitcase. There was a lot of talk about how some of his fingers were dangling out of that suitcase. At one point,
with a baseball bat.
Sarah Boone, in previous interviews, said that she thought George might be able to get out because he had access with his 2 or 3 fingers to the zipper. Of course, that never.
How are you? Welcome back. And in Sarah Boone fashion, the trial's been postponed another day. So we have another motions hearing, and we continue on with jury selection. But I did, yes, they did it. I shit you not, an hour ago. An hour ago they changed it till tomorrow. So I've updated my thumbnail. So just watch the thumbnail time. That's the time. I'm officially really, really starting to dislike this woman. But I was, as I said, creative today, and I think you might appreciate it, especially if you liked my suitcase. If you like my suitcase humor, someone wrote a song dedicated to Sarah, and perhaps I'll play it for you, shall I? Are you ready? This is going to be our theme song for the trial. Now, you have to listen closely to the words. All right? Ready, and go.
So my name is Sarah Boone, and I'm on file for my life. And my defense in this darn trial is that I'm just a battered wife. My boyfriend George and I would drink and end up in a fight, till a game of hide and seek caused massive changes overnight. You see, we had been drinking wine, and I was probably off my face. And my boyfriend thought it cool to put himself in a suitcase. When I zipped him up inside, he started calling out my name. So I recorded what he said, cause I thought he was so lame. I was so drunk that I passed out, woke up with a thumping head. And when I opened up the suitcase, I found my boyfriend who was dead. Now they charged me with his murder, and I've been locked up in this jail. And my fate may be decided from my recordings of his wail.
Yep, it's not finished yet. Wait for it. It's still coming.
At first I claimed an accident, and in my statement I would say that the game of hide and seek is what we both wanted to play. And then I got some useless lawyers that were really effing dense, and they refused to change my claim to make it out of self-defense. So now I'm on my ninth attorney, and 5 long years has been a while, writing letters to the judge while I've been waiting for my trial. So when James Owen saw my ad and chose to help me save my life, he then put forward a new motion to claim defense for battered wife.
I'm always.
So let's see who has the power. But I might stink during the trial if I don't get a doggone shower. I want my chippies and Pop-Tarts and a box of cookies too, and maybe add to that some water and some peppermint to chew.
There you go. That's what I achieved today. Yep. I love AI. I just wrote the wrote the words, chose the genre. Did you have a laugh? Did you fancy some brute scooting? I made it. I made it, Kelly. I wrote it myself. No copyright here. Yep. There's an AI app online, and yeah, I just wrote down what I want. You can actually even just write the bare basics, like you can say, I want you to write me a dramatic introductory song that is all about cats scratching each other. And then you tell it what kind of tune you want it, whether you want it pop or funk or hip hop or country and western or whatever, and it will write the lyrics for you. Or you can customize it, which is what I did, and wrote the lyrics and then just put in the genre. And that's what it came up with. It's called, I'll put it in chat. It's free. You just create a free account. You have to log into it online. You don't even have to download the app, and it saves all of your creations, and you get, I think, 5 free creations attempts per day, and then they there you go. That is the AI app. But yes, I actually wrote that myself. So there you go. All right, let's continue. Yep. So that's going to be our theme song. If this trial ever starts. Let's keep watching this guy. Hopefully he's got something interesting to tell us.
Happen. So the state, made their point, and then the defense got up and said, look, because a couple of his fingers were sticking out of that suitcase, that is the overt act, that there was a chance for him to get out and attack Sarah Boone. So in exchange, she whacked him with this baseball bat that has now been revealed. She hit him with this bat and ultimately left him in there. Who cares? Says she was literally the aggressor, and that's exactly it. I mean, she's the aggressor. I think everyone is wondering why the defense is going with this. I've talked to other criminal defense attorneys who quite simply have said, look, she's reaching for anything now. Yep, that's Toy B. I would have to agree.
Over letting in
someone saying, am I ready for lunch in the wind? Yeah. These lunch lives are obviously a little chaotic, different than our studio shows, but just roll with us. So the defense came out again and basically said, look, their argument was she feared that this guy, George Torres, could get out of the suitcase and attack her, and that's why she left him in there. It rings hollow to me.
But it was an accident.
But this went on for a while.
She's so good.
And then before this was resolved by the defense counsel said hand, not finger. They did say that today, but previously it was alleged that a couple of his fingers were coming out. And that could be a point of contention or argument. Obviously, will be between the state and the defense. Was it a few fingers?
If you can't laugh at yourself, you can't. Yeah, you just have to. You have to. And in shit like this, what else are you going to do? What am I going to do? I just have to make the best of it and write stupid songs and make stupid ads about suitcases. It's a stupid fucking trial. Any updates on that weather, Ida? I did try and have a quick look in amongst my scrambling to try and get together another stream in the time frame they allotted me before they changed and postponed it again. It doesn't look like it's changed or it didn't, as far as I could see. But as I said, it was only a quick glimpse, so let us know how that is. They say it's not supposed to. Oh, good. It's going to go out to sea. Shit-ot. Excellent. Good news. Good news. We've actually got some really nice weather here coming this week. Really nice. It's actually humid today. All right. So the motions hearing that's holding us up is apparently the defence pushing for this battered wife defence approach, and the state is opposing it, and that's what's holding the trial up, apparently.
Was it a hand? But imagine getting just a couple of fingers smacked by a baseball bat
Yeah.
while you're zipped into a suitcase. It's kind of crazy. In the middle of all this, Detective Chelsea Copsel, who is literally eating 15 feet from me in a enclosed area that is not windy, she's there with a bunch of people from the Orange County Sheriff's Office, and she essentially said, she was in court, and at one point, James Owens asked if she's going to be testifying. Why is she here? If she was afraid, she wouldn't have gone to sleep. Thank you. It is tough to read these comments because I'm looking at them on a tiny little cell phone here. And I'm getting old and I'm losing my eyesight. So at this point, Detective Copsel, who was sitting in the gallery, she looked up and was like, "What? They're talking about me." And the defense said again, "Is she going to testify?" The state, Will J, he stood up, the prosecutor, and kind of in an angry voice said, "I said no state's witness today." It was the most kind of tense exchange of the day. It's an odd thing. At some moments, James Owens, who is Sarah Boone's defense attorney, seems at odds, at loggerheads with Will J, the state prosecutor. Other times they seem to get along, but in this particular case, this instance over what Detective Copsel was doing there, it got definitely a little heated.
The be pushing hard too.
The bottom line, with going back to in this battered spouse defense, the bottom line ruling by the judge was essentially the state gets some, the defense gets some. So the defense is allowed to talk about battered spouse in the opening statements of this case. And I want to look at my notes here. Hang on one sec. Here we go. The judge is going to accept and deny part of the state's request to keep battered spouse out of trial. That was the motion that was first heard today. The judge is not going to prevent the defense from using battered spouse altogether. However, excluding battered spouse testimony, it will be excluded until evidence comes in to the trial that is upheld by Judge Kranick himself. The judge does say that the defense can invoke battered spouse in opening statements. So the bottom line here is they can talk about it in opening statements, I guess refer to what battered spouse is, but they can't get into details of it related to Sarah Boone during the trial unless there's some new evidence that comes in that we simply don't know about. What's intriguing about this is James Owens only got this case 45 days ago. That's not a lot of time with the amount of discovery that's here. So I just don't know. And I'm going to try to ask him when I see him. I keep bumping into him in the elevator. Does it have to be dichotomous, either or? Could she be terrified and malicious? That's a question more for a psychologist, but the law.
I've got a feeling, because the way they're saying that they can't bring any new evidence, or they can't bring anything in unless it's new evidence, because I know they've got all of this documentation on, the domestic, the DV reports and all that that there is a history there, because there has been charges laid. George was charged 3 times in 2019, and Sarah was charged in 2018 as well, both under DV, but they can't bring that in unless she testifies. I think that's because she has to lay the foundation for that. So I think that's what they're hinting at, and I guarantee you, she will get up on that stand at any opportunity to testify. And I think that's the only way they might be able to bring in that evidence, because George isn't here to tell us. So, and they bring in the documents and reports. That's hearsay. So, I think she wants it to go one particular way, but doesn't understand how to get that in with it. You know what I mean? She doesn't know the process but she'd still be pushing. She'd still be pushing him to do it her way and to do it that way, and that's the way she wants it done, regardless. So I just think it's just going to be a back and forth. I am keeping an eye on the motions hearing. It hasn't started yet, and we'll switch straight over to it as soon as it does.
The law states there must be an overt act. And then the state used an interesting analogy about a dog, about, if a dog's biting you, and then you zip that dog into a suitcase and it's yelping, but you don't let the dog out of the suitcase. It can't hurt you, can't bite you. You just leave it in there to die. So it was kind of a weird analogy, I guess. I think it fell a little flat with Judge Kranick. But the point is, back to this overt act. There was no overt act. There was no threatening moment for Sarah Boone in that instance. And so there was no reason for her to ultimately kill George Torres. Now, keep in mind, they also brought up police interviews, and that's again when, well, not police, but sheriff's office interviews. And this is when Detective Kopsel, or Kepsel, forgive me I'll get the pronunciation right, that she had told authorities, Sarah Boone did, that everything was fine that day. They were getting along. They were playing hide and seek, that they were enjoying the day, that they were doing arts and crafts. All this is a little weird to me for grown adults, but each his own. So they, played hide and seek. And according to the state, Sarah Boone ran upstairs and hid in the shower. It's unclear whether Owens put himself in this position for whatever reason. It's a great point. He did. He answered her request for an attorney. But the state claims that Sarah Boone, according to the evidence, went into a shower to hide. George Torres put himself inside a suitcase.
Ready or not, here I come.
Sarah Boone zipped up that suitcase, per what was discussed in court today, left enough room for a couple of fingers or a hand, according to the defense. And then, if you've seen this horrific video, she taunts him, and she says to him, this is for what you've done to me. Laughing at him as he's crying for help. He's literally saying, Sarah, please get me out of here. It seems very cruel and inhumane. But again, the defense is going to say she was in fear, and this is why she
was
left him in there. It's going to be up to jurors to buy it. So, again, that ruling, in terms of battered spouse, it can come in opening statements. It cannot come into the trial, which that's a whole other question for a bunch of attorneys. What do they do if they can't find this evidence, or if the judge doesn't believe it's substantial enough evidence to let it in? Then what?
Maybe that's what they're doing. Maybe they're just trying to buy time, and they've got half a dozen legal assistants going through all of the documentation, trying to find something to bring in. I betcha.
does her defense become? I've talked about this with Jessica Mishali, and she said she would just go with the fact that she was drunk, wasted,
Yeah.
and
Accidental.
simply just, they're playing a game and she fell asleep. Why they're not going with that, I have no idea. Because
Good
as
morning,
nutty as Sarah
Giselle.
Boone is,
Good
and
morning, sweet
by all
peeps.
appearance,
Welcome, 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 welcome to another trial delay. Woohoo! Yes, an hour before it was to go live, the feed changed the date and time, postponed it another 24 hours. So here we are. We're just watching this gentleman who is on the lunch break. He's been at Orange County Court watching the proceedings, and he is from the podcast Surviving the Survivor. So he's giving us, yeah. That's not half of the words that I used, not even close, because I've spent, for me to prep for a live trial starting at midnight, I'm pretty much jacked up on so much caffeine. Yeah. But luckily, as I said, I didn't start my energy drink just yet, so that's a bonus. But she has forced me to break out the chicken inner biscuits. I will be opening those during this motion. Like I said, it's got more motions than a gastro ward. So yeah, it seems like they're arguing over rebutted spouse defence, and they're still going to finalise the jury, but we shall make the most of it. And I will play you my song before we end the stream. I'm just watching the feed. They haven't started the motions hearing yet, so we'll just keep this guy will update us on what's been happening in the court.
says she is a quirky woman, even in the
Quirky?
courtroom. If that was the defense, I might say to
Quirky?
myself, yeah, she's a kind of
She's a
little bit of
fucking
a
nut job.
wacko. Maybe she's a drunk and this happened. But this whole battered spouse defense, I don't know if it's that Sarah Boone is pushing it or not. And this is true from Dog Mom. Sarah herself said that they were just playing. So play does not equal an imminent threat.
We'll just have to have a Friday night a-thon. Oh, she's entering the courtroom. She just looks so prissy. Look at the smirk on the face. Really, really starting to dislike this one. Really. I wonder if she had a shower today. Where's my chippies? I want my chippies and Pop-Tarts. And some mints. Give me some mints. Just a smarmy. All right. I will wait until we have. Keep watching this. Until we have sound in the courtroom.
Or an overt act coming from George Torres. So it just seems, again, like it is ringing a bit hollow. There was another motion to review the decedent's medical records. That is a legal term, otherwise known as the dead guy, George Torres. And obviously, we feel for him and his family. The state let it be known in court yesterday that the night before, so 2 nights ago, the state got 550 pages of medical documents. One relates to a 2018 incident that George Torres put his hand through a window.
I'd like to give her a colonoscopy with a broken chopstick.
The issue here, the defense wants to bring all this in because it kind of shows that he's I guess a loose cannon getting into trouble. And the state immediately got up and said, look, there is no report of violence attached to this. It was just a hand through a window. The state said, look, we suspect that if Sarah Boone is to testify, she's going to give an example of how this was violent behavior. And then talked about like the relevancy of him going in and getting treatment. What the state was trying to say is for this portion, which is 57 pages out of the 550, that you do not, the jurors would not need to see all 57 pages, that the majority of those 57 pages were irrelevant. That's what was being weighed. Then they talked about another incident. So of the 550 minus the 57, they're all related to a Christmas 2017 incident. George Torres was attacked by his brother. And the state said, look, it's not relevant that he was beat up by his brother. And for them to add this to the case seems like it would just be hearsay.
Can you imagine the
people talking about what happened outside of the medical record?
We have sound. Let me boost that sound up.
Ma'am, good morning. Can you state your full name and date of birth for the record for me? Ms. Boone is seated in counsel table wearing a dark gray suit and a yellow blouse. She is in custody. However, she is not being shackled for the purposes of the trial based on the court's prior findings. We're here to conclude the objections as identified in the state's response to defendant's fifth amended reciprocal discovery exhibit list. The court has reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address, state, before we begin addressing those objections?
Judge, I do not see a written order from yesterday's rulings on the court's website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions in limine or any case law that presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office. I wasn't anticipating.
Change that overlay.
Okay, that's what I wanted clarification on. Thank you.
But I just do want crystal clear clarification as to what we are both doing. Because based on that, I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment. You did not. Okay. Madam Clerk is advised that court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that.
Thank you.
Madam Court Reporter, how long do you think that would take you? Is that acceptable? Can we address it at 1:30 before we come up?
Makes it very difficult to prepare for opening statements.
No, I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box, but
I understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But Is 1:30 acceptable? Okay, well then, short of taking a break right now and having her create it, I don't know what else to tell you. State?
We have an out-of-state witness and people that are
Yeah.
scheduled to.
Everyone's really starting to dislike
There's
this
some
chick.
problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir? Okay. Correct. That's correct. Okay. Mr. J?
I just need that
Yes.
ruling. So
Yes,
that
it is.
with enough time to prepare.
Certainly.
I understand. So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do. Or we can stop now. Madam Clerk, Madam Court Reporter can provide a rough draft of what was ordered yesterday. And we could go over it and review it, make sure that we're all on the same page as to what the court's ruling orally was yesterday as to the various motions in limine. Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed. I understand your concerns of running afoul with a motion in limine. I totally understand that. But it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury selection so that I have time to rework what my opening statement will be based on the ruling during Mr. Henderson's voir dire.
Let me then ask this question. Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every waking moment we have to not waste these jurors' times until 5 o'clock today.
Okay.
How many people in that courtroom are cursing her? Madam Court Reporter, the judge, the state, all the witnesses that the state has called. Yep.
Madam Court Reporter, how long do you think it would take you? Is that acceptable as opposed to in print? She could go back and pull back the audio from and re-review it and just provide it to us now? Okay. All right. Then we'll take a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
State or Ms. Rollins? How long do you think? 10, 15, 20? Okay, great. All right, we'll be in recess till 9:45. Thank you. Yes, sir. Yes, sir. Yes. You're talking about the motion in limine regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Fine. Okay, well, that saves me some time then, so I appreciate that. All right, so do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial? All right, motion's granted. All right, we'll be in a brief recess till
One down
9:45.
until they find another one.
Off the record, thank you.
They're just throwing motion after motion after motion. It is ridiculous. All right. Go back to. I'll close that up. No. Right, let's see what he still has to say.
Would not know the true story. Were any of George Torres' family in court? No. As far as I know, absolutely no family was in there. There was 5 people in the gallery, and I think they were all with the Orange County Sheriff's Office. I've not seen any family members that I know of Sarah Boone's or George Torres. How was the hair and makeup, Joel? Looks like she had some kind of little pencil eyeliner on, for sure. She's just interesting to watch because she does not stop moving. She just
No, she's got to be in
moves and
control.
moves and moves and or talks and talks and talks. At one point, she turned around. The private investigator was sitting in the gallery, her private investigator, and she was kind of whispering an entire conversation with him. I was trying to make out what she was saying. It was tough to because I was on a weird angle. 2017, Sarah was still married to Brian. That's a good point.
She's having an affair with
I don't know much about like marital infidelity there, but it sounds like there may have been. And by the way, he's going to be a state's witness, but also may testify for the defense. So when it came to all these medical records, this 550-page document done, James Owens then got up for the defense and said, "Look, Judge, we only got this case 45 days ago. I can't even tell you the amount of pages that I had to go through. So I was kind of looking for a little bit of sympathy
you chose it,
from the
mate.
court." And then he turned to Will J., the prosecutor, and said, "Hey, you didn't get all these medical documents?" And Will J. looked incredulous. And he said, "No, I haven't. They must have been sitting in a box." This is a problem when you're on your 9th defense attorney. This was another tense moment. Will J. looked really annoyed that he was being questioned about whether he had seen all these medical documents. So the judge basically said to the defense, "Look, you are the proponent of evidence. You have to establish evidence." He said this to James Owens. He said some of the medical records must be narrowed down. And he said charts, medical follow-ups, all these extraneous things that are part of these 500 documents cannot all come in. So that's how he handled that. The state got up and said, "Look, the defendant," he now pointed the finger at Sarah Boone directly. He said the defendant has had these medical records since 2021, and he pleaded, "Joel, save time to eat, hydrate, don't get sick, please. COVID is setting in." You guys heard that one of the jurors, potential jurors who was in court yesterday, positive for COVID, and as a result was now eliminated from being a potential juror. And another woman who thought she had COVID tested negative. So COVID is floating around. You know that I'm going to get.
This is why we're having 6 jurors on the panel and 8 alternates. 8. I might see if I can find where I saw those medical records.
It's just a matter of time. Even if I get it, I'm just gonna, I don't know what I'm gonna do, but I hopefully won't get it because I've had it so recently that hopefully I'm immune. But back to these medical records, the state said, we're not asking for much. We just want the medical records narrowed down. And Will J., the prosecutor, went on to say, "I'm sure that Sarah Boone's testimony is going to be that George was the aggressor, and that's why he was beat up." And there was also an issue that at the time of one of these beatings, I believe it was when he was beat up by his brother at this Christmas party, George had a BAC, a blood alcohol level of 3.1, which is way over the legal limit. But the state was saying, well, what's the relevance of having a high blood alcohol level? The defense obviously is going to try to bring that in. The judge on this ruled that why George Torres was seeking medical treatments is admissible. He said that the blood alcohol level is potentially admissible and relevant. He did not completely rule on that right now. But again, he said that this vast amount of medical records is going to have to be narrowed down substantially. So expect that to happen. The defense also was objecting, this was at the very end here, to some of the state's digital evidence. And because of that, they had a long discussion, and it looks like some of the digital evidence, it wasn't completely clear exactly what all the elements were. Some of those will be limited as well. Just looking at a couple of other things here, the body cam footage that came up earlier on, and also the interviews or the interrogations at the Orange County Sheriff's Office. Again, that is at Orange County Courthouse right behind me where this trial is happening. But as it pertains to body cam footage, police interviews with Detective Copsel, the defense made an argument that some of it needs to be redacted because it seemed prejudicial, that the law enforcement officers were potentially prejudicing the jury. And the judge actually did agree with that and said that certain elements, I don't know what, so certain pages discussed, but I don't know what specifically, but those will be redacted when it goes to actual trial to the jurors. They will not see the complete, full, unabridged version of the interviews. They will be slightly edited. So that is a mouthful. I just talked for 23 minutes and 59 seconds. Is there a final question or two? And then I will say goodbye and see you guys 4 p.m. Eastern today. We are taking the Menendez brothers press conference, the Menendez brothers press conference, which yesterday they made it seem, by the way, like it was the district attorney holding this whole thing. Today, it sounds like it's more of Menendez's extended family. 24 members of his family will be at this press conference outside the courthouse in downtown Los Angeles. There's a possibility that DA George Gascon will be there, but we're taking that live at 4 p.m. Tim Jansen might hop in to commentate on that. And then again, at 7 p.m. tonight, this evening, you've got the living legend, Dr. Ann Burgess is here. And you've got Erlinda Johnson, the special prosecutor for the now disastrous Alec Baldwin trial. And last but certainly not least, our good friend Tim Jansen, the famed Tallahassee defense attorney. If you like the content, please subscribe to the channel. Please hit the like button. We've got a Patreon page. Working hard. We love what we're doing, but we're working really hard behind the scenes to bring you all this amazing topic. Off topic. Favorite case you covered, Joel, from Nicole? Wow.
I'm just trying to find where I saw this. Oh, it might be on Twitter. Yeah, it might be. I saw this site where they were talking about this medical information. And I can't for the life of me remember where I saw it. It's not where I thought I saw it. How about we have a look at what's going on Twitter? What the hell? God, this trial is never going to start. It's exhausting. Always some delay with Sarah Boone and her attorneys to keep this from commencing. Yep. Update. All parties want to have openings today. That could happen this afternoon. On the docket to begin a second day of jury selection. She needs to be able to shower for today, thankfully. Day 2, motions start with the prosecution asking for an order of minutes documenting the judge's rulings, so they can prepare for opening statements. Update. Yeah. Sarah Boone walked into the courtroom. The ice princess wants her juice boxes and snacks. Where the bloody hell did I see it? I even sent about an hour before this trial was supposed to start, I sent Broken Baker an email saying, oh my God, it's finally here. I can't believe it's actually happening today. I never thought it was going to start. And I sent him a copy of my song. And halfway through the email was when I saw the time change and went, bugger, spoke too soon. Yeah. Oh, uncivil. I should do a stream with him. I know he was looking for someone. I'm sure it was in here. I like that picture. The sign says, not intentional. Know that. Well, apparently they have a jury for um, the Delphi trial. So they've been able to manage that. All right, well, this is where I was this morning because I remember seeing this saying loony boony. So, where is it? Yep, I've lost it. Now it. Well, at least. Actually, I wonder if Jules has got. At least I know where to go to keep up to date on the most recent stuff. At least I got an hour's notice instead of like a minute's notice this time. Thank you, Twitter. I don't normally get on. I just hate social media. I know I'm on YouTube, but I'm not like a social media troll or anything like that. I don't. The only reason I have social media accounts is to share my YouTube. That's it. Nope. No. Anyway, it was worth a try, but nothing there, unfortunately. My apologies. So, thanks, Tricia. The other stream that I had listed that I had to swap over to, we had actually, no, that was the motions, yesterday's motions hearing that I was streaming this afternoon. We had a couple of new people come in to chat and sub, which was really, really nice. So, yeah, I think we're down to 78, I think. is what we're up to before we can start doing all the fun stuff. You start doing members only streams and, live behind the scenes 101s and just fun stuff like that. I like doing all that shit. Did I put these up? Yeah, I did. How about a word from our sponsors? Why not? Oh, where is it? She didn't save it. I can't. I just can't. just can't. This trial is going to, I can see it now, it is going to do my head in. It is 100%. So you're just going to have to help keep me sane. I'm sorry. Okay. Ready? A word from our sponsors. Hello and welcome to our suitcase mega sale. We have lots of different various colours available for you to choose from. We even have a replica vintage selection. You can choose inner lining as an optional extra, and they are perfect for travelling. We also have both new and used models in stock. No returns on the used. They all come in a variety of different shapes and sizes to suit your needs. And you can choose between a hard or a fabric outer surface. But wait, there's more. If you order now, you get a free roll of crime scene tape, but no extra. But only while stocks last. There you go. That we're sponsored by Suitcase Mega World, whoever they may be. Let me see what ow, my back. Let me see what Mr. Baker is up to, because he was, I think he just put his I think he just postponed his time and added another 4 hours to it in the hopes that they they get through this shit today. Why is that doing that? Baker. I actually think he's live, but we'll have a squeeze. We'll see if we can stalk him. Yeah, no. He's not going live until another 3 hours. He was smart. But I did save some little snippets. That's right, I did. There it is. There we go. Share this tab instead.
Judge, my client tells me that they wake her up at 2:30 in the morning, and then she's kept in a holding cell until she's brought to court here at 6:30 in the morning. And then, of course, she's brought up around 9. And then she'll leave today about 5:30 or 6 and be in 2 different holding cells. She'll finally get to her dorm about 9 or 9:30. They stop allowing showers after 9 p.m. She got there after that time, but they allowed her to shower since she hadn't had one. She's asking that, they get commissary there at the jail. She's asking that the officer that escorts her be allowed to bring her commissary. She's asking for 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, and a bag of either cookies or a Pop-Tart to allow her through the day. I think they serve them a peanut butter and jelly sandwich down in the basement lunch, but she's not diagnosed with any kind of blood sugar, but she says she gets like today, she's feeling tired and lethargic. And so she feels like those items during a break that she could have something like that to keep her energy level.
Poor Sarah's been
I'm
inconvenienced.
asking for the court's permission that she be allowed to do that.
State, any response?
Not the state attorney's office and any of the parties involved.
Okay. I will speak to the captain of the jail if I can get a hold of her before 5 o'clock tonight and see what, if anything, we can do. I can't make any promises. My understanding from the deputies is that there are 2 bagged meals which are given, which include cookies as well, that are provided for Ms. Boone. And that's for all inmates that are stored downstairs during trials. So I'll inquire of the jail staff if I can get a hold of them this evening, and hopefully have an answer, if any, tomorrow.
Thank you, Judge.
All right. Anything else?
That's one.
Sarah Boone in court to the suitcase murder trial. Trial not opening up just yet. They're still working on getting that jury seated.
You're back.
Sarah Boone. We get appearances for the state. Okay, Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Ms. Boone, a third of your defense team is not present at the moment. Are you amenable to proceeding without Mr. Beck being here? Okay, thank you very much.
Lucky.
Well, that cures itself. Counselor? Thank you. Record reflect that Mr. Beck has just entered the courtroom. All right, the court's had the opportunity to review the excerpts from the motion in limine hearing from yesterday. And my understanding is both the state and the defense were provided copies of same. Mr. J, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate? Yes. Okay. The court's reviewed it. Are there any questions with regards to the court's rulings on that motion?
Yes, Your Honor.
Yes, sir.
My understanding is that based on
Sure. Madam Clerk's providing you a printed copy, sir. Bless you.
I really like this judge.
Have you had the opportunity to review that excerpt yet, Mr. Owens? All right, go ahead and take a look at it.
So you can see Jules in the back. That might be her behind Mr. Owens in the white, right next to the door. Perhaps. Can't really get a good look. She just looks so pretty, doesn't she? I don't know if anyone's watching it, but I've been sleep streaming the burned husband trial, which I didn't realise is going for over 2 weeks. But it's Melody Farris, Georgia versus Melody Farris, and she's accused of burning her husband in the fire pit. Her
All right, Mr. J, you may proceed.
testified last night.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings there were several motions yesterday, but in this one, it's on page 1, lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not in our motion, though. But paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916 Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida First DCA case from 1984, also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page, Florida 4th DCA, 1971, Reed, REID versus State, 213 Southern 3rd, 1110 at page 1111, Florida 5th DCA, 2017, Rudin versus State, 182 Southern 3rd, 724 at page 726, Florida 1st DCA, 2015. So what we were asking for is, in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid, was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled the battered spouse syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent.
Thank you. Response.
I just have one question as to what time. Are we talking about for Dyer? Are we talking about opening statement? At what time are we talking about?
During the testimony in the trial.
That was my takeaway.
Okay. He's absolutely correct.
Okay, then the motion's granted. So the court's going to rely on that specific excerpt in Holland, 916 7 2nd 750 at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on a particular occasion, section 90.4041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was, or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted. Received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
No, Your Honor. And then the only other thing that we beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday at some point for the record for the 6th DCA.
Okay.
Yes, ma'am.
All right. Thank you. Anything further from the state before we proceed with the objections? Defense.
Judge, yes, just my overall understanding is that the motions and the orders that the court has apply to trial and the organization or the flow of the evidence at trial. Certain things have to be presented before certain witnesses can testify. It has nothing to do with or diet nor open statement.
That is correct. And the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right. Thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today. Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that fifth amended reciprocal discovery exhibit list filed by the defense, I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to, provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
One by one, I assume?
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4, et cetera. So we can ping pong it back and forth from there.
All right, regarding item number 1 on the fifth amended reciprocal discovery exhibit list from the defendant, I do not believe we have received those records.
Response from the defense.
We're referring to 1. 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Motions or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment by.
I'm not talking about 2. You don't object to 2. Talk about 3.
Well, I do need to talk about 2 now because
Okay.
This morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense, which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Miss Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
At this point in time, the court is going to proceed with a Richardson hearing. Defense?
Judge, referring to our paragraph 2,
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27th, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a
I'll look it
Richardson
up.
hearing. Court is conducting a Richardson hearing at this time. The 81 pages are not at issue.
Thanks, Jeff. To determine if there's a violation of discovery rules. Okay.
And what do the 119 pages evidence?
Their medical records from the hospital relating to Sarah Boone over a period of time. So obviously that's going to be whittled down depending on her testimony and whether or not it was cooperative. Her testimony that she suffered an injury at the hands of George Torres.
I need more specifics than that. I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured, which would coincide with the.
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time. So I need to address the inadvertence or will.
That's why I did have a laugh at the fact that the judge wanted 8 alternates for this. With this jury pool, more than the actual jurors required, because can you imagine if we got to like the last week and we were down a juror? Because that would, the way this trial's going, well, it hasn't gone yet, but the way this is going, yeah, the likelihood of something like that happening is pretty freaking high. It's funny you say that, because I actually think that one of her strategies, apart from changing her defense 3 times, but one of her strategies is possibly just to baffle them with bullshit and, yeah, find some legal technicality somewhere in there. I really think that they're just buying time at the moment. I reckon behind the scenes they've got half a dozen law clerks scrambling to try and find some evidence to support this battered spouse in amongst all the boxes that she had in her cell. Yeah, they're just wasting time, throwing motion after motion after motion, just to buy some more time so that they've got more time to look for something. But actually, I should have put a poll up, but there is no doubt in my mind that this woman will absolutely 100% get up and testify in this trial. 100%. She can't help herself. She just
Willfulness
won't be able
of
to.
the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things? Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the three prongs that I need to address.
So the state is putting forward this motion, is that? Or this is the objection that they've made? Let's see if I can get.
My understanding is the first 81 pages were medical records of Sarah Boone that we'd gotten from one of the previous lawyers that we had sent to the state. The other medical records were those that we had requested directly from the hospital that we got last week or late last week. And we just failed to immediately provide those.
When did you receive them last week? Okay, I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what. Understood. All right. I'll make a note to circle back to this issue. Moving to number 3.
Okay. So what I've just heard, the defense produced 87 pages of documentation that the state approved with, no worries. Then they subsequently found all of these haphazard JPEGs and tried to submit them. And they weren't in the proper format. They basically, hang on, let me just rewind and see what he said. Actually, I might share it because he explains it a lot better than me. So this is what they're objecting to in this Richardson hearing, explained by legal advisors. Oh, I'm already on him.
So I need to address the inadvertence or will.
Okay, time to take a pause on the live proceedings here just to explain this to people. I've been Googling furiously. A Richardson hearing takes its name from the landmark Supreme Court case Richardson v. State of Florida. In Richardson, the Florida Supreme Court held that the trial court has an affirmative obligation to hold a hearing, a Richardson hearing, once it is put on notice that there has been a discovery violation. And that's what's being argued here. The prosecutor arguing that the defense violated their discovery duties. And Christine Perkins says this is why she's mad at the prosecutor. It's this stuff. This stuff is important. This is the rules. The defense lawyer is not playing by the rules, according to the prosecutor. They said, because they had originally produced like 550 pages of medical records 3 days ago. And they objected to that and said, these are irrelevant documents. They involve things that have nothing to do with this. And so they whittled it down to, he said 87 pages, I think 81, 87 pages that they gave. And he said, okay, cool. We have no problem with these 87 pages. These are the ones you plan on giving. They said, yes. And then they came in with this other document that wasn't even a document. It was just haphazard JPEGs was 100 and however many of them there were. They should have been all aligned in the same direction, put in one single PDF file and given it to them. But they came in after they said that this is what they were going to submit. They gave them in probably an improper format. They violated the rules of discovery. So they said, we need a Richardson hearing on whether or not this can be included. So what the judge has to do here, the court has an affirmative obligation to hold a hearing once it's put on notice there has been a discovery violation. During the hearing, a trial court must first determine whether a discovery violation has occurred. If a violation has occurred, the trial court must then consider whether the violation was inadvertent or willful. Was it an accident or was it on purpose? Whether the violation was trivial or substantial, important violation, or is it just kind of a trivial violation? And 3, whether it has affected the defendant's ability to prepare for trial. If a trial court determines that a discovery violation has occurred, the consequence can vary based on the severity of the violation. Possible sanctions may include a court-ordered exclusion of the improperly disclosed evidence, granting a continuance, I hope not, or in severe cases, dismissing the case entirely. Well, that's not going to happen because they're arguing it was the defense lawyer that violated the discovery rules. All right, that's what a Richardson hearing is.
Is this the Advent Health Winter Park Jorge not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
You want the exact pages that those
Yes,
the DAC and the narrative are on?
that's what's going to be offered into evidence at this point in time.
We'll work on that.
Appreciate it.
I've got staff here in the
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them.
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense.
Judge, we have not yet received those records. We had Sarah Boone sign a medical release, and we have sent requests to various medical facilities asking for records, and we're just waiting on response.
The objection is sustained. Moving to 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages of jail records regarding Ms. Boone. Once again, I'd spend my personal time reviewing these records. Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through
Smear
for
tests.
4 years. The state
Breast exams.
just is having great difficulty understanding what, if any, pages of these records are relevant.
Mhm.
On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225 goes through alcohol abuse, yes. Type, spirits, not wine. Last used 2/23/20, several times a week. The intake screening also includes a history of violence towards others, yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed. There's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that was pre-existing before jail.
You think?
So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020.
It's all a load of bullshit.
And quite frankly, most of it's just embarrassing and irrelevant. And it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results. And we struggle to see the relevance, Judge.
Thank you. Response.
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
We addressed that yesterday. That's not germane to the issue.
As soon as I got the medical records, I sent them to the state. He mentions anxiety was pre-existing. Now, that's not what their expert, Dr. Werner, opined in her deposition, that the anxiety she maybe suffered from at the jail was from being in the jail. So there are questions about that. But generally, you get these records, as you know, when you have a forensic psychologist that's trying to evaluate a patient.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant? What specifically is relevant? What page? What date? What document? You're not answering my question, counselor. They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
I don't intend on introducing these exhibits. I intend on potentially the doctors, the experts, Dr. Werner, Dr. Harper, to rely upon these records.
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper? If she has not reviewed these records yet, when do I get to depose her? Who's going to pay for the expedited cost for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post-deposition, post-evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st.
Too late.
Took her deposition either the 1st or the 2nd. So this is also a problem.
Don't let him
It's
in.
going to be relied upon, not introduced, and I appreciate them letting us know that they don't seek to introduce these records into evidence, because of course, experts can rely on inadmissible evidence if within the course of that area of expertise, it's the type of evidence that's routinely relied upon. But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. We would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens?
Judge, I don't want to go into trial. I'll wait. I will not have Dr. Harper.
So she has not yet reviewed these yet, correct? Okay.
I don't want to get in a situation where we will take another deposition. So I'll wait. I will not ask her to
State with, okay. So state understanding that tactical decision and that Ms. Dr.
Doesn't look
Harper is not
happy.
reviewed and seemingly will not be relying upon these
He
experts.
doesn't
Does
look
that cure any
happy.
concerns that you have?
Yes, sir.
All right.
Could have fidget.
Then based on counsel's representation, the court's not going to sustain or overrule the objection as the defense has identified they're not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11.
So did you notice as soon as that he didn't do, like he said, all right, we won't enter them into evidence, and she realized that she'd lost that battle, she starts fidgeting. She moves all of her stuff and lines it up in front of her. Let's have a look. Just watch. You watch the face. She starts doing this. And then she moves everything and lines it up neatly in front of her.
State understanding that tactical decision and that Ms. Dr. Harper is not reviewed and seemingly will not be relying
Starting.
upon these
Here we
experts.
go.
Does that cure any
Oh,
concerns that you have?
Oh,
Yes, sir.
no,
All right.
it's got to be neat. Move that. Yep.
Then based on counsel's representation, the court's not going to sustain or overrule the objection as the defense has identified they're not going to be seeking any of these 382 pages into evidence.
Yeah.
Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself.
Definitely.
What is your response to that, Mr. Owens?
So the arrest reports are not listed as evidence in itself, but the reports may be used to refresh the officer's memory if needed during the testimony.
Okay. Does that cure that understanding? Okay. All right. So based on Mr. Owens's representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry, 16. 16 is a repeat of 11, so the court's going to adopt its, or similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing? Okay, so court same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection?
No, Your Honor.
Response?
The defendant is not intending to introduce the jail.
Okay, the objection is sustained. 18, prior criminal history of George Torres not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously we have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about prior interactions with the state attorney's office.
Okay. Response, Mr. Owens.
Judge, we're referring to the prior record involving Sarah's
Okay.
Yep. In other words, she has to testify.
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent? Can't rebut it.
Yep.
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion. Because if it's oral testimony, that may be a different critter once the overt act is established under Holland.
So to introduce these records from the DV to support her battered wife, or what is battered spouse, whatever, defense, she has to testify to lay the foundation. She's the only one that can. But what they're saying is that George isn't there to rebut it. So if there isn't any physical medical evidence to back it up, it's a verbal, it's just an oral statement. But again, testimony is evidence. So yeah, what if she gets up there and spouts a whole lot of BS? A whole lot more BS. At least that's how I understand it. Can you hear that okay? Because when the the lawyers stand up, they're not next to the microphone, and I have got it boosted, but I can go a bit higher if you need to. Just let me know.
I don't think there is going to be anything about a prior criminal history other than what she's testifying to.
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that, that we have to cooperate and ask the court to take some judicial notice that there was a case file that was set up to handle that criminal prosecution.
Okay. Mr. J?
I don't know that papers generated by a government agency is relevant. The disposition of the papers that were generated by some government agency is relevant. What's relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits. And that's what our objection would be to believing that what was represented was a criminal rap sheet.
Such part of battered spouse syndrome, that Dr. Brennan testified, Dr. Crumble testified, Dr. Warren testified, is this feeling by a victim of being battered that she has nowhere to turn. His family can't help her. She has no room. The state attorney dropped 3 of the charges. 3 separate times George Torres was arrested, charged with violence against Sarah Boone. And her request, she wanted them dropped. That's part of the syndrome. But in addition, in her mind, she felt like the state attorney had let her down. They could not, they dropped 3 of the cases. So she felt helpless that there was some outside entity that would protect her. That ties into her state of mind as to whether or not she felt at the time of this event. So
Apparently, not too far away, she puts her hand up like she's at school, like, excuse me. Hello, want to say something? Hello, oh, over here. Remember me? Defended.
that may become relevant depending on what Dr. Harper says, Dr. Warren says about that, what Dr. Brandon says about that, as to whether or not she felt helpless because the state attorney's office was not prosecuting George Torres when she was.
But that all sounds like oral testimony. And again, this goes back to this is an exhibit list. What are the exhibits? Tangible, physical.
We may want to introduce something in the court record indicating that the state attorney is.
Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list.
I will withdraw the prior criminal history.
Okay. All right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objections.
Could you imagine if she was pro se during this? Can you imagine? I do believe Mr. Owens deserves a medal.
Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19, Orange County Sheriff's Office investigative workup report. Response.
That's to be used to refresh the officer's memory if need be during their testimony.
Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay. So accepted. Your objections overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding George Torres. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I color coded this and I miscolor coded this one. Okay. Then based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because we kind of addressed this as well with number 19. Anything further, argument state. Anything further, argument? Okay. I'm going to overrule the objection as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence. Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-0.
That's for
O.
divorce papers, I think.
I understand the state's objection is to relevance and hearsay. Response?
Why does he have to pay her alimony? The fuck?
What does the non-payment of alimony
have to do with this?
have to do with what's happening in a family case?
Judge, that goes to his testimony, that goes to his credibility, whether or not he can be impeached.
Oh, fuck off.
The position that she's in now, he's biased, and to show that he's biased, that he has not paid alimony for supposed to pay $1,000 a month for a number of years, that he's just failed to comply with the order. That shows his personal bias or feelings.
Well, he wasn't a biased witness when you wanted to call him to reiterate how many times he had witnessed DV between the couple to support their battered spouse syndrome. He wasn't a biased witness then, but now the state's calling him, apparently he's biased. An adverse witness. Fancy that.
Response?
Sounds like this is ongoing pending litigation that has not been
Yeah.
decided by a circuit court judge in the Ninth Circuit Family Division.
Got
I
nothing
certainly
to do
understand
with
why
George.
one may believe they don't need to pay alimony when their spouse is incarcerated.
Uh-huh.
I can certainly understand why somebody may believe they don't need to pay child support
Uh-huh.
when their spouse is incarcerated.
Yeah, help.
And they would probably want to seek legal redress about those issues. And it sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of a hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation
clapping
to
his
pay alimony.
hand.
And I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into.
What's that got to do with
But it
anything?
sounds like there's pending litigation, including a relocation and I don't know because that's not my case. I haven't looked at it.
That's been decided. He has been able to relocate. I don't know all the ramifications. I'll look at the court file. I think we had subpoenaed the custodian of the records of the court file. I'll look at it and I'll let the court know and the state know.
Can you all approach this for a moment?
The fuck? Why should he be paying her alimony when she's incarcerated? She's not paying any. She has no responsibilities over him. She hasn't. It's not like he can have sleepovers or they go out for dinner or anything like that. What? Oh. It's because her earnings are less than his. Simple as that. So that is bullshit. So not fair. So not fair. He's out there doing the right thing, working hard, looking after their child. And she's in there being a princess and expecting him to pay her as well. Like, give me a break. That face, that. There we go. How's it go? Writing. L. Oh, don't give us a close up. We don't want to get that close. Far out. Yeah. Did you hear my song, Tricia? I wrote a song. Today about her and her story. I think it's hysterical. That's just me. And I do not understand why they're going over this shit. Why is it so? Why? You didn't hear it? Well, you're in for a treat. Ready? Brace yourself. This is I did it via AI. I wrote the words. And this is our theme song for the trial. Okay? Ready? And oh, that's the end of it. Sorry. Let's just start again.
So my name is Sarah Boone, and I'm on the file for my life. And my defense in this darn trial is that I'm just a battered wife. My boyfriend George and I would drink and end up in a fight, till a game of hide and seek caused massive changes overnight. You see, we had been drinking wine, and I was probably off my face. And my boyfriend thought it cool to put himself in a suitcase. When I zipped him up inside, he started calling out my name. So I recorded what he said, cause I thought he was so lame. I was so drunk that I passed out, woke up with a thumping head. And when I opened up the suitcase, I found my boyfriend who was dead. Now they charged me with his murder, and I've been locked up in this jail. And my fate may be decided from my recordings of his wail.
Yeehaw! Yeah! Not finished it. And go solo.
At first I claimed an accident, and in my statement I would say that the game of hide and seek is what we both wanted to play. And then I got some useless lawyers that were really effing dense, and they refused to change my claim to make it out as self-defense. So now I'm on my ninth attorney, and 5 long years has been a while, writing letters to the judge while I've been waiting for my trial. So when James Owen saw my ad, chose to help me save my life. He then put forward a new motion to claim defense for battered wife. So let's see who has the power. But I might stink during the trial if I don't get a doggone shower. I want my chippies and Pop-Tarts and a box of cookies too, and maybe add to that some water and some peppermint to chew.
There you go. That is the only thing that's going to keep us sane throughout this trial. Did you spit your coffee out? Yep. Yep. So we all have to do that. The boot scooting. I sent a copy to Broken Baker because I figured he's got a similar sense of humor to me. So whether he uses it or not, it's up to him. But yeah, I did laugh. All right, wench, come on, let's get this shit sorted. Oh, they're still on a sidebar. L.
Okay.
I'm no longer seeking to introduce those.
Okay. All right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action.
Maybe we should make that a theme. Everyone has to. Did you hear that, Tan? Been lurking in the background there. We should make a theme that we have to wear our I'm gonna have to find one. a cowboy hat.
Moving to 25, records from Tealwood
I'll
Park
send you a
Apartments.
copy of it.
Judge, we never received what we wanted. We're not seeking to introduce that.
Based on counsel's representation of not seeking to utilize it, court takes no action on that objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay, all right, thank you. Moving to 27, the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
State, do you have such an item in your possession? News footage?
No, not that I know of.
All right, but we have not received it, so we don't have the evidence.
Okay, all right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name, not going to read it, it's very long.
Judge, I do not intend to introduce 29.
Okay,
I've sent the email to you, Jen. And if you hadn't already guessed, they postponed it literally like an hour. I was sitting here an hour before and I thought, I'll get on Twitter and I'll have a look. And I shit you not, I watched it click over. Yep.
court takes no action based on counsel's representation. Moving to 32, iPhone photo. Yeah, I'm sorry, sir.
29, what is the ruling?
There is none, as the defense has advised they are not seeking to enter it into evidence. 32, another iPhone photo file name.
Oh,
Very
for
long,
goodness
so I'm not
sake,
going to read
The
it.
defense does not intend to introduce.
Takes no action.
Judge,
There
Go.
was no.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that. But that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right
Mm.
to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission that constituted second-degree murder. So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So in an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day. And that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes to directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
Yes, sir. Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion to eliminate. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion, and that if that is the proffered testimony, that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. That they weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do. And we're making every effort to make sure that we understand how this trial is going to go down and how they, and Ms. Boone understands how the trial is going to go down. Because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day. And right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony, unless there is. Then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah, shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not. She let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, George Torres died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Any rebuttal?
I wanted that in writing weeks ago. She was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state's expert. The characterization that Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Warner, 5 of us there. Dr. Warner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment. Because I can't testify to what she said. The two prosecutors can't testify to what she said. The only two people that can testify to what she said is Dr. Werner and Sarah Boone. We just dispute their characterization of what she said. That's just going to have to be testified to by Sarah Boone and then Dr. Werner. And jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder. It's something I was asking for a couple of weeks ago. Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraphs 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the costs of expedited transcripts. I just want to make sure it meant to overrule that request.
I apologize because I was just looking at what was articulated in the exhibit list, which was any and all relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed later.
I believe those are the same witnesses that they've listed in regards to the prior incidents, the deputies that went out on the call outs and the cases that resulted in cases in the state attorney's office and 911 dispatchers.
Okay. Is that accurate, Mr. Owens? That October 3 states list?
But yeah, we don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Okay.
Judge, again, I'm not complaining. Been on the case 45 days as we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, you know, Sarah Boone has a right to trial. Sarah Boone has a right to testify. Sarah Boone has a right to appeal. I believe those are the three fundamentals. But the defense lawyer makes the decision about which witnesses to call. So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them, and it may not. We may not call many of those that she wants to, but I believe my right to do that and to present our defense with our witnesses is paramount, and she does not have the right.
Okay, thank you. All right, court's going to take a brief recess to address this and the Richardson violations. We'll be in a short recess. Thank you.
Oh, whoops. Well, I don't know if I highly doubt we're going to get to opening comments, opening statements today. Sorry, I'm just posting my link into Twitter. because I thought I might share my song. Why not? One day, I might be famous. You never know. All right, copy link address. Let's see if this works. Paste. Oh, it does. All right, well. Oh, it worked. It worked. There you go. Let's let's see if Jodie becomes famous. All right. What are the updates so far? Let's have a look at what the tweets are. Tweedly-diddly-dee, tweedly-diddly-dee, woohoo, tweedly-diddly-dee. All right, well, look at that. There's one at the top is me. sharing my song. Sarah Boone, defence, second degree is a serious charge. Why does the state have to make that claim? Oh, me. Zip boyfriend into suitcase and videotaped when he said, I can't breathe, and Sarah numerous times said F you and laughed. Okay, don't get that one. Okay. Now, Jules was asking about why. Oh, no, that was later. She did actually ask for advice on what the law was regarding paying alimony to partners incarcerated. But this post just 5 minutes ago, she's written, the state is reciting what Sarah said during the time that he was dying, begging for his life. And apparently there was absolutely no reaction from Sarah, not a tear, frown, or a grimace. The state says that the medical examiner will testify that Sarah Boone kicked the suitcase, hit it with a baseball bat, and flipped the suitcase over. The medical examiner will say that George died from positional asphyxiation. Yeah, and she legit doesn't care at all. Nope. What else has been said? The demands are that Sarah wanted holistic treatment in the jail for her ailments. Oh, apparently she made a lot of demands and complaints about the jail. No, not us, Sarah, no. Oh, I don't believe a word of it. Don't see that happening. Made a lot of demands and complaints about the jail. State feels none of this is relevant. Mr. Owens argues that they are relevant. The judge asked, how is COVID tests and other ailments of this nature? Defence conceded not to enter the evidence as to not delay the trial. Oh, good one. And that's when she fidgeted and did the OCD shit. She sounds like Letitia Stout, yeah. I think she's worse. She's worse. What else have I got to say? Sure wish we could hear Boone said, yeah, his mic isn't very good. All right, let's see what everyone else has to say about what's going on in the court room today. The state is now reading audio from the suitcase video. Sarah is staring daggers into prosecutor Will J. Defence has their heads up. State, that's our case. It shows her depraved mind and utter disregard. Also have new statements that she shook the suitcase, hit it with a bat, tossed it down the stairs. Defence, wish I had it in writing weeks ago. I do not agree with his assessment. Dan, that was awesome. I can't wait for this guy to cross-examine her. Yeah. Hell yeah. Let's refresh it and see what the updates are doing while they're oh dear. Oh, yeah. Oh, who put that up? I'm going to skip that because I don't. Can you imagine being Sarah Boone's hairdresser? Because there is no way a professional wanted to do that. Mhm. Sarah Boone. Oh, Richard Allen and Leilani Simon trials are all happening. Oh, okay. Yes, this lady is the one. The toddler in the dumpster trial that's on, and I'm pretty sure they said to the jury in the Delphi case too, didn't they? Pop Tarts check. Defendant Sarah Boone is asking the court for snacks during a murder trial. Yep. Julie on Court TV says that the accused suitcase killer has the diet of a 6-year-old. This has turned into a shit show, and the real reason we're here has been forgotten. Correct. And should be found guilty. She should be found guilty as charged. The key should be thrown away and call it a night with this clown. Yep, there. I said it. Oh, we got some boobies. Don't know what that's really. Apparently, there's a chick in Asia somewhere that's called Sarah Boone, and yeah, looks like inappropriate material. We'll skip that. Me waiting for Sarah Boone trial to begin. I love it. I love it. Can I share that? How do I share that? Share post or copy link. All right. Can I copy that link? Where? I put it in chat? Maybe. There you go. See if you can see if that works. That's gold. I like that. Learned today that jury selection is boring. You think? Yep. Imagine having to teach lawyers what the law is and schooling them how it applies to their case during a motions hearing. The defence is arguing that Sarah was scared George would get out of the suitcase and harm her. Mm-hmm. Out of fear, she also hit him on the fingers and hands with a baseball bat. Insane. The guy was trying to escape to save his own life. True. Not pleased with the state reading her text. I'll get rid of him, referring to George Torres. When was that posted? Oh, yesterday. No, I want the latest. Not, ugh. Live stock market. No, don't want that. Sarah Boone. Read that one. After seeing what's going on in court today, I believe that she is dictating her attorney. She's dictating her attorneys. Oh, absolutely, she's telling them what to do. Most attorneys would put their foot down at some point. Yeah, but can you imagine the tanty that she would have? Imagine the tanty she would have if he said no. And yes, I agree with this lady. Why should he pay alimony for someone who's in jail? Well, he's the one paying all the expenses, yep, of their underage child. So Sarah Boone also could care less for her own son, not surprised. True that. True that. There was one in here that said that she put her hand up. I couldn't believe that she rejected the plea deal. She's going to regret that decision when she's convicted and sentenced to life. Yep. There's a lot of people called Sarah Boone on Twitter. I've just realised. What happened to the presumption of innocence? A la Sarah Boone. That applies to every accused, not just those with weak lawyers. Sarah Boone definitely trying to skew a facial reconstruction and a hand surgery as some vague proof that he was violent in some way, whilst neither had nothing to do with her. Will be a clown show. Prosecution will be allowed to counter any argument the battered spouse syndrome. Meanwhile, defence pushing for the documents of the George Hospital records from 2017 and 18 to be included at trial. Sarah Boone walked into the courtroom. The ice princess wants her juice boxes and snacks. Yep. There was actually a good site on here that I wanted to follow. It's a YouTube channel, but I think it's an alternate feed, potentially alternate feed to the two big guns, and it might be worth following because we all like another option. It was Jules that posted it. Where is Jules? Now I've lost her. I don't know how to work, obviously. Oh, that's it there. Follow. Let's follow. Shoot the shit with squeegee. I like that. I think Brandy Churchill was going to be at the court today too. Or she was at least going to try and make it for the opening statement. So, that's all back from yesterday. All right. Come on, peoples. This is really. Actually, I think I need to get some more painkillers, just quietly. Because my back ain't good. It ain't. Oh, shoot. I'm supposed to start that. Okay. I'm going to have to change that. Oopsie daisy. And then trying to do two things at once. And I've got crossed over. I'm supposed to be sleep streaming. Just change the time on the other one. Edit. I think I'll put in another hour, and then I'm going to call it. I think. I don't know how much longer I did before. And we've got 3 weeks of this trial to get through. give me strength. Where am I going to get that from? There's only so much sugar you can consume. Mm-hmm. Only so much. And I'm getting wearer. That's the only problem with being on this side of the equator. For Melbourne, for me to stream live, Charles, it's 2:16 in the morning. So when they give you stuff all notice that they're altering the times of the trial, it's okay if you're in the US because it's like, oh, well, you know, the difference between 9 a.m. and 10 a.m. isn't really a biggie. But if it's the difference between 3 a.m. and 4 a.m., yeah, kind of. And if you know you've got a trial coming up, you have to plan your entire day like you're working night shift, pretty much. And yeah, you get to the point where you're like, yes, it's going. And no, it's not. But you've had so much caffeine, you can't sleep anyway. So, and then you start talking shit on YouTube whilst you're waiting for their recess to be over. Don't know what you're talking about, Jodie. No idea. It's gone back to normal. I had it on 1.25, but I've caught up. Damn it. And because we've had this happen twice, I don't really have much else to show you all. So somebody all right, what's happening? All right, let's talk other trials. So I got onto Monroe County Clerk's office or the clerk's website today and downloaded some of the updated documents from Ty Tucker's recent status hearing. And they included, what did it have in there? It was download. All right, so the court minutes were nothing. It was just two little things. There was his motion for continuance, the motion for disclosure of impeachment material, and requests for missing documents. So apparently he had a heap of documents that he was going to use and rely on, but obviously couldn't bring them all with him when he was reincarcerated in April. So he's listed a heap of documentation that he needs to be provided with again because he hasn't got access to them. They were left at home. So there was that one. PDF. Can I bring that up on the screen? Slides from my computer. Yes, I can. Okay. Let me see. That way you can see what I'm looking at. But there wasn't a great deal in there that that really gave me any sort of information. That makes sense. Let's have a look. How do I zoom out? Full screen layout. Where is it open? bloody hell is it open to? Well, that's a bit silly. It won't let me zoom. That's just dumb. 'Cause I can't see that. Ty's handwriting is bad enough, but no, I can't even. Let me go back and see if I can embiggen it. Let me embiggen. Okay, so should we continue? Maybe I can share the screen. That might be easier, and I can zoom it at least. Yeah, that's better. You can get off. Remove. Ooh. Okay, that's our Sarah screen. That can go. And share screen. Okay. Ta-da! We got there. Sorry. I'm not the best at IT. And I'm certainly not the best at IT this time of the day. Right, can you all see that? So this is his motion for continuance. It was dated the 26th of August in the Circuit Court of the 16th Judicial Circuit, Monroe County, Florida. Okay. Yes. Yeah. When did you speak to him? Can you say hello to him for me next time you speak to him, please, Christine? And I hope you should give us if you speak to her, give us an update on how he went with the hurricane and everything. I hope that everything is okay. All right. Comes now, pro se defendant Franklin Tyrone Tucker moves this court to bring the motion to continue and reschedule the current date for trial. Oh, that'll be right. We're back. Far out. Yep. Please second.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
William J.
Defense.
James Owens for Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from earlier this morning. All right, it is 11:24. With regard to the Richardson hearing with regard to item 6 in the defendant's fifth amended reciprocal discovery list, the court is going to reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6 was cured by.
Does that mean it's going to be postponed again?
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
Then what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 is the 119 new JPEG pages, according to be from Winter Park Advent Health, and they're a little bit different than the 81 pages that I previously received.
Okay. So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to offer into evidence, Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's.
You're going to speak to Ty on Monday, are you? Okay, cool. Can you, would you mind saying hello for me? And telling him I'm sent him my best wishes and hope that he's got through that hurricane okay. All right, darling. And yeah, I think he's got he should have my email address. If he needs to I know he's got my phone number, so if he needs to contact me, he's more than welcome to. I'll be speaking to Steve tomorrow, actually, so I've got a meeting with him tomorrow. Sorry, Saturday, to go over some stuff. So hopefully we'll have another update shortly.
Response. Those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
All right, Judge, the same as should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
State response.
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, we've got a substitute analyst. So that's our reason for the late disclosure on her. And who were the other 2?
Rochelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for the expedited transcripts. What I would expect will not be lengthy nor expensive.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Cacciatore does not believe that the defendant ever deposed that person.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have the thing again, please? If you all still have yesterday's sheets from jury selection, Madam Clerk has advised that jury services has told us the juror in seat 25 wearing badge 63 called. The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any. So stipulated. Juror number 25 wearing badge 63 will be struck for cause. We'll advise the jury services to call them and tell them they do not need to report. With regard to the Orr tennis motion as to Ms. Boone's request for snacks, the Orr tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record.
So what's happening now? They're recessing for lunch, are they? Oh, poor thing was denied a snacks too. Oh, she's not going to get her Pop-Tarts. Dear. How long did they say they were going to be? Did they say they were going to recess for a particular time?
The juror in seat 25 wearing badge 63 called here due to caring for that child will be struck for cause. We'll advise the jury services to call them and tell them they do not need to report.
So I'm guessing is it 12:30 there now? No. Yes. Is it? No, it's in Florida. Is it 11:30 or 12:30 there? Because if they're going to take an hour and a half for lunch, yeah. Does anyone know what the time in Florida is? Shall I Google it? It's 11:30 in Florida, so they're going to be back at 1. Yeah, no, no, no. I might stream that in the morning. Yeah, it's 2:30 here now. If I wait, that'll be 4, and then I've got another 4 hours of jury selection. It's not going to happen. Sorry. Blame Sarah. Her fault. So by the sounds of it now, they've delayed the trial again until tomorrow, but the actual feed says that, like my time, midnight, which would be 9 a.m. Florida time, yeah? So their plan initially was to be finished by lunchtime today with, well, yesterday, with jury selection and motions. And then the defence submitted additional motions last night, which is why they had to address them today and postpone the trial. And so now this afternoon, they've got to finalise their jury selection, and they were hoping to get that all done this morning so they can start openings this afternoon, which would be now. And alas, now, 9 o'clock tomorrow, they have to address the additional crap that they just mentioned about the Richardson's hearing. They're going to have that in the morning at 9. So hopefully they get the jury seated this afternoon, and then all they have to do is address this Richardson hearing quickly, which the Richardson hearing is basically trying to establish whether or not there was a discovery violation by the defence, and they have to have all their paperwork submitted prior to 9 o'clock. Well, then the judge will have to review that and make a ruling. So I can only guess that if it's quick, they can start their opening statements. If not, it'll be lunchtime. That's my guess. It's yeah, exactly. She's just spent the last 5 years wasting everybody's time. This is why I don't like doing live trials. You are a pain in the ass, lady. All right, well, we go out with a bang and have another jig of the song before I say la vie. Yeah, why not? Thank you for watching. I wouldn't normally do motion hearings and jury selection, but given that I'd set up the stream and prepared myself, I thought, may as well. Sorry, Teresa. Yes, same time, same place, same bat channel. I'll be here. Again. Yup. All right. I'll run this song and then I shall say adieu.
So my name is Sarah Boone, and I'm on file for my life. And my defense in this darn trial is that I'm just a battered wife. My boyfriend George and I would drink and end up in a fight, till a game of hide and seek caused massive changes overnight. You see, we had been drinking wine, and I was probably off my face. And my boyfriend thought it cool to put himself in a suitcase. When I zipped him up inside, he started calling out my name. So I recorded what he said, cause I thought he was so lame. I was so drunk that I passed out, woke up with a thumping head. And when I opened up the suitcase, I found my boyfriend who was dead. Now they charged me with his murder, and I've been locked up in this jail. And my fate may be decided from my recordings of his wail.
Banjo solo. Only someone who truly knows this trial would appreciate this.
At first I claimed an accident, and in my statement I would say that the game of hide and seek is what we both wanted to play. And then I got some useless lawyers that were really effing dense, and they refused to change my claim to make it out of self-defense. So now I'm on my ninth attorney, and 5 long years has been a while, writing letters to the judge while I've been waiting for my trial. So when James Owen saw my ad and chose to help me save my life, he then put forward a new motion to claim defense for battered wife.
One more. Yeehaw!
So let's see who has the power. But I might stink during the trial if I don't get a doggone shower. I want my chippies and Pop-Tarts and a box of cookies too, and maybe add to that some water and some peppermint to chew.
Boom. There you go. You'll be humming that all night. Good night. I bid you adieu. I'll see you tomorrow. Arrivederci.
Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests. Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests.